Have the pleasure now to be joined by two of the experts that we have in our industry that touch on the world of compliance. To my right here is Allen Denson, who's a partner in the Washington, D.C. office of Hudson Cook, and also joined here with Shaun Petersen, who's the Senior Vice President of Legal and Government Affairs with NIADA. So please welcome these two gentlemen to the stage. So, Allen, let's begin with you. We're most of the way through 2016 now. Thanksgiving is next week, but let's rewind back to the beginning of the year. There's been definitely some enforcement actions handed out by the Consumer Financial Protection Bureau involving Buy Here, Pay Here dealership in Colorado, some much larger, well-known industries. So if you could just kind of recap some of the highlights that have been most germane to the auto finance space and the enforcement action slice of what the CFPB has done so far this year.
Sure, I'll give you some stories from the front lines, as it were. And just so you all know, most of my practice is in helping folks who are being investigated or examined by the Consumer Financial Protection Bureau or the Federal Trade Commission. And so the first case that you seem to be referring to is the case out in Colorado, which is the Herbie's auto sales case. And that is one that I was personally involved in. And I first of all want to thank the Herbie's folks for allowing me to speak about that. Otherwise, because of ethical considerations, I wouldn't be able to talk about it. But I really do appreciate the Herbie's folks letting me speak. So Herbie's is interesting because it really focuses on, I think, the way things can. Way you can get upside down with regulators on kind of the front end of your process, so on sales. And what the Herbie's folks got in trouble for is really three aspects of one major thing, is a hidden finance charge. And there were three ways that they had a hidden finance charge. So number one, they had a warranty that was included in the price of the car, but it was only included in the price of the car for your credit customers and not for your cash customers. So that's one aspect of the hidden finance charge. The second was they had a payment reminder device that, again, was only included for credit customers but not for cash customers. And even though it was included in the price, people who were paying in cash were effectively not paying for that charge. And those, none of those aspects of the hidden finance charge should really seem that outrageous or that novel to anyone. But I think where the CFPB got really novel and experimental in their case is this third aspect. And they said that Herbie's would mark up the price of their vehicles comparatively more for their credit customers than they would for their cash customers. So, the example would be if you had a 2007 Toyota Camry, the sales price for the credit customer might be $14,000, and they said if a cash person were to buy that same vehicle, their data allegedly showed that cash customer would have received a discount. Now, all of this is theoretical. Herbie's agreed to a settlement because it was just in their best interest to settle the case, and who knows what would have happened if there were litigation in court. But this is a really radical and novel theory that the CFPB came out with. So this idea that they are going to test your sales and see if you are marking things down more for cash customers than you would for credit customers, on a statistical basis, you may have a hidden finance charge. And you would have to disclose that in your truth in lending disclosures. And it would have been nearly impossible for Herbie's to be able to do that, because think about what the Bureau is asking for them to do. They need to take each sale, and they need to be able to predict what the discount would be for somebody paying in cash versus credit, and that's impossible to do. Every sale is unique. Some people are effective negotiators, some people are not effective negotiators, and so how would Herbie's ever be able to predict for that unless they just charged one price, the price, and there's no negotiation. And that is really kind of the box that the CFPB pushed Herbie's into. And then just kind of the final aspect of this case that I also think is novel and unique is Herbie's did not post prices. Customers would come onto a lot, they would qualify based on what their income was, and then they would get put into cars that fit their lifestyle and budget. And customers would shop to the payment. They wouldn't shop to a particular vehicle's purchase price. And the CFPB had a major issue with that, and they saw that they felt that pricing was opaque, that customers didn't find out until the end of the transaction what they were going to pay ultimately for the use or purchase of the car, and that was a problem because they found out late, and they had potentially at least wasted their time until the end of the negotiation process. And so what you see in the Herbie's order is that they have an obligation now to post prices on all their vehicles going forward. And kind of, I think another interesting part is what Herbie's response has been to this. So, rather than, focus on, all right, how can we make our buy here, pay here practice and sales comply with the CFPB order, they've just gotten out of that line of business. Now they're doing leasing. So that's interesting.
Very, very much so.
So do you mind if I jump in here with an observation? What you heard Allen say the word unique a couple of different times and novel a couple of different times. And I think that the Herbie's case is representative of the way that the CFPB handles their enforcement cases, which is neither novel or unique for them. It seems to be the way that they handle these things. They'll take a kind of a surefire, gotcha, dead to rights type violation. They'll use that as their way in the front door. And with respect to this particular case, I think we saw those certainly with two of the three aspects of the hidden finance charge allegations, probably dead to rights type claims. And then they'll take this novel theory, this unique theory, and they'll try to percolate it and expand their case law. And I think for us, one of the lessons learned from the Herbie's case is that, if we think that the CFPB is going to only pursue these novel theories, I think we're missing the boat. That dead to rights kind of gotcha violation is their way in the door. And then we need to be prepared for defense of these unique and novel theories.
And then how do you adapt to that going forward? I mean, you've got this settlement on the books that the CFPB expects everybody else in the industry to follow. And then, how do you adapt to that? I think it's a real challenge.
Well, that certainly was a case that got 2016 started on a.
It was the first case of 2016
on a noteworthy basis. As the year progressed, what were maybe one or two other incidents of enforcement actions that have been particularly noteworthy in your opinion?
So I think in particular in the auto finance space, like the other area where you have seen a lot of activity is in collections. And you saw a really huge case right at the tail end of 2015, beginning of 16 against Westlake and Wilshire. And that was a huge dollar settlement. I think it was $44 million in restitution and a few million in fines. And this kind of, I think this is an interesting case because it kind of shows, what can go wrong in the collection space. And so what the allegations were in this case is that Westlake and Wilshire had a web-based program, so something provided by a service provider. It was called Skip Tracy, and Skip Tracy would be able to mask your phone number. So and it would make what you decided you wanted to program in there show up on caller ID. So the things that they were accused of here was number one, like making the caller ID show that you were from a repossession company when it would really be just the Westlake or Wilshire employees calling. Number two, so in the CFPB's view right there, that would be convincing people that repossession was imminent when in fact it wasn't. So in their view, that's a deceptive practice. The second thing that they would do is they would allegedly mask caller ID to trick people into picking up the phone. So if they had been unable to contact folks, they had a way where it would show like John's Garden Shop or pizza delivery, and that would trick folks allegedly into picking up the phone. And so the CFPB took issue with kind of both of those practices. And what I think is kind of a stretch application for this is, and what I see a lot of people struggling with is what's your social media strategy? And I think that there are a lot of folks I've seen who are being creative, and they want to find ways to track down the customer and reduce their delinquencies. And so they might be inclined or feel like they've got to find ways to use social media to do that, and that can be a really effective tool. But I think the application from Westlake and Wilshire is if you were doing that in a way that deceives people or makes you think that either repossession is imminent or increased or enhanced collection tactics are imminent, or that disguise your identity. So you pretend to be somebody's friend on Facebook, and you find their location services that way. I think that that's a real way that the CFPB could kind of expand in the Westlake and Wilshire orders.
Shaun, what would you like to add? Any color to the enforcement action segment of our conversation here?
I think Allen did a fantastic job, and like I said, I think the CFPB is out there patrolling and looking for different ways. And going back to the Herbies case, just to give you an example of how they're finding these types of cases. This is something, and I had a chance to talk to folks at Herbies a couple of weeks ago about this very thing. How was this case found? What was it? And Allen can answer the question better than I can, but it sounded like it was just them going through an advertisement, right? Some kind of a
there was an
trade
article,
journal or some kind,
Yeah.
and they saw this little snippet about it and said, this doesn't look right. And that led to this, $700,000 settlement and all kinds of hassle for Herbie. So the idea of the CFPB going after the big guy is now dead and gone. This is a small operation.
Well, not only in the enforcement department, the CFPB certainly has been active this year involving its rulemaking authority. Several proposals have come out so far this year. And Shaun, let's turn to this next segment, beginning with you. Rule proposals have come out involving arbitration, debt collection, even small dollar lending. While there's not auto finance in the title, there's auto finance impact. So if you could please take us through some of the components of those proposals and how they might be connected to the auto finance.
Sure. Let me start with the arbitration proposal, because I think that's probably the one that everybody is most familiar with and is garnered the most headlines and probably received as much comment as any. The CFPB was created years ago. They were given the authority from Congress to study the use of mandatory pre-dispute arbitration agreements, and they went through this comprehensive study. They reported back to Congress, and part of their authority from Dodd-Frank is if you feel like you need to do some kind of a regulation on the use of arbitration agreements, you may do so in the consumer financial marketplace. And they took Congress up on that opportunity, and the CFPB in its benevolence said, here our proposal is we're not going to go so far as to just ban these things outright, but we are going to regulate the use of the mandatory pre-dispute arbitration agreements and prohibit you from including a clause in there prohibiting consumers from participating in a class action suit. Now, the problem with that is multitude problems with that. I guess I shouldn't limit it to a singular problem, but if you look at the study that they submitted to Congress, the only value to this class action proposal, only beneficiary are class action attorneys.
Shocking.
Yeah, what a surprise, huh? The constituency of well, we won't go there. But if you look at the study itself, there is ample evidence in that study to suggest that arbitration is faster, it's cheaper, it's more effective, and it benefits the consumer $450 million, I think, roughly $450 million in class action attorneys' fees over the class action cases that the CFPB studied, when compared to an average of about $33 and change in consumer restitution. Something just doesn't seem right with that huge disparity. So there was a significant number of comments opposing that arbitration proposal. The rule is still pending. The CFPB is in the process of analyzing those comments. Now there's a glimmer of hope, and we'll get to last Tuesday here in a minute, but prior to last Tuesday, there was a little bit of a glimmer of hope, at least in my mind, in that I think that there was a recognition from folks on both sides of the political aisle that the CFPB had gone too far, including a letter from Congressman Neugebauer and Congressman Clay to the director of the CFPB saying, we really need to pull this thing back and go through a process. We want you to study this arbitration issue again and come up with a rule that's not going to adversely impact the very people that you're there to protect. So we'll certainly see what happens with respect to that. The other rule proposal that's on the table right now deals with the small dollar payday lending and high cost installment loans. And really what is apropos to that rule for us in our industry, there were several of us that commented. AFSA had comments that kind of covered the whole gamut, but those of us that are specific to the auto finance space, including the dealer associations and others, joined together in some comments to make sure that the CFPB stayed within the box that they were at least publicly intending to stay in, meaning that this proposed rule that would require creditors to go through an ability to pay analysis and have an all-in rate cap of 36%, that proposal, although there may be other issues as it pertains to folks that would be governed by that rule, didn't bleed into purchase money security interest like we would do in a retail installment contract. So we commented to the CFPB that what you have on paper may not be clear enough to ensure that purchase money security interest, including all of the components of the transaction, be it ancillary products, be it negative equity, be it taxation, that all may be a part of the retail installment contract that consumers are paying over time, doesn't get wrapped into this 36% all-in APR and the ability to pay analysis that needs to be done. So we'll see what happens. There's a lot of comments that were filed on that as well. There's been a lot of political pushback. That's very much in its infancy. And then the last one that's really, it's not an official rule proposal yet. It's still in the idea phase, is the debt collection proposal that the CFPB has. CFPB was given authority to promulgate rules under the Fair Debt Collection Practices Act in addition to their UDAP authority. And what they've done is they've taken that Fair Debt Collection Practices Act authority and proposed some ideas on what a rule might look like as it pertains to third-party collectors collecting somebody else's debt. And the interesting, there's 4 goals that the CFPB has with respect to these proposals, and let me just read them to you real quick because I find them kind of interesting. And the entire concept of their proposal fits in one of these 4 categories. They want to substantiate the debt that debtors that collectors are collecting. They want to accurately identify the debtors. They want to provide debtors with appropriate information about the debt, and then they want collectors to communicate with debtors about debts respectfully, lawfully, and a consumer-oriented way. Not sure what that last part means entirely, but I'm not sure. We'll see how that fleshes out. But in any event, there's a lot of issues in that proposed rule, even though it applies only to third-party collectors at this point in time. It's not a proposed rule, these proposed ideas, that would pose problems if they get incorporated into some kind of a future rulemaking as it pertains to first-party creditors collecting their own debt. One of the big ones is a limitation on how many times you can communicate with that debtor and the ways in which you can communicate with that debtor. The CFPB, again, pre-Tuesday, has indicated that they intend to in the future do some rule as it pertains to first-party creditors collecting their own debt. So these issues are very apropos to all of us in the room, even though that this particular proposal may not apply to us.
Well, Allen, let's turn back to you as recapping everything that Shaun just recapped for us. As someone who's been asked to serve as counsel for Herbie's and other dealerships and finance companies, just how much more of a challenge does that present to you to consider the what might be, what if of all these rule proposals that are being discussed? Just as the potential counsel for these entities, how much more of a challenge does your responsibility become?
Well, I think that the rules would not be retroactive if they're ultimately approved, and that kind of gets into a recent case that the CFPB went through. They sued a mortgage lender, PHH Corp, and there was an appeal. It went all the way up to the D.C. Circuit, kind of the level right below the Supreme Court. And in this court case, they said, CFPB, you can't write rules retroactively, so you can't punish people for conduct that occurred before you had adopted an interpretation or issued a rule. So that's off the table for them now. They also called the agency structure unconstitutional as well. So this fact that they have a single director who can't be removed but for cause, they struck that provision. And so now Tuesday is really important because President Trump could, if this order stands up, could remove the CFPB director, and that has, where I think we're going to get into it, has all kinds of implications for these rules.
And it's a remarkable. And not only is it an interesting political battle, it's an interesting legal conundrum too. What we're hearing is that the CFPB will likely file what we call an en-banc a motion for an en-banc review, which means that the D.C. Circuit has 11 judges on it right now. There's a panel of 3 that heard this case, and then the 2-1 decision is the outcome of this, finding this structure unconstitutional. There's a whole bunch of other things in there dealing with statute of limitations issues that are really important.
Yeah.
And we'll probably get to those too. But from a civil procedure standpoint, they can make this request to have the entire court hear the case and rule on it, and we're hearing that they will likely do that. So if they do that and then file a motion asking the court to stay the decision from this 3-judge panel until the full court has an opportunity to rule on it, what can the president do come January 21st? And then does the president have the authority to withdraw, the president-elect, I guess, does he have the authority to withdraw that motion? Does he have the authority to, if they decide to do something in the Supreme Court, does he have authority to withdraw? I mean, there's a lot of interesting things that are going to go into this.
And they've got a big political decision to make too, because if they're able to, if the Republicans are able to remove the director and put in their own person, it seems like the Democrats have this calculus. Do we accept the CFPB as a commission, so approve legislation that changes the structure? Because they've got to recognize that if we get a single director in there who is a really conservative Republican, that we may not like that result as much as we like having a commission. So it's possible. I think that you could see legislation changing things before the D.C. Circuit fixes anything.
I think that's right as well. And to Allen's point, one of the interesting things as it pertains to these proposed rules that are on the table, the CFPB does not have the authority to promulgate or implement a rule without a sitting director that's confirmed by the Senate. So if Director Cordray is fired, if he quits, and there is a significant rumor floating around the state of Ohio that he is going to run for governor in 2018, I grew up in the state of Ohio. I was an Ohio resident for all the last 20 years, up until 6 months ago, and I've got all my friends that are calling me saying, hey, Cordray was in town and he was given the grand opening speech at the local library and all these sorts of, so the rumor mill is that the campaign has unofficially started, so we'll see what happens with respect to that. But none of these rules can be implemented if there is no sitting director without Senate confirmation.
And certainly, first thing tomorrow morning, we'll get even deeper into these potential topics. Chris Steinbert, the President and Chief Executive Officer of the American Financial Services Association, is our opening speaker tomorrow morning, and we'll share some unique perspective of what's going on within the Capital Beltway. So in our closing minutes here, we discussed not only just a few minutes ago, but in our call beforehand to kind of close with the presidential election and the impact that's potentially coming forward. So Allen, we'll begin with you, and then Shaun will allow you to close. Just again, the assessments of the outcome, just what you've heard either from your contemporaries or just industry dialogue, just how much of a, to steal a cliche, a Pandora's box, or however you'd like to moniker it, might we be having in light of what's happening with the CFPB thus far?
So I think, I don't think the CFPB is going away. I've heard some people kind of suggest that. I think that you probably see a commission structure ultimately, and I think you see a pullback on a lot of these rules. So I would guess that like arbitration may be in trouble. I think small dollar may be in trouble. We may not even see the debt collection rule actually get proposed. And then I would guess that you see actually a little bit more of a focus on enforcement from the CFPB. Maybe they bring some different types of cases and that are not quite as aggressive as they have been, but I would not think that because we have a change in administration that compliance is going to go away. There's a lot of mainstream popularity for what the CFPB is doing, apart from some of these like really radical rules. And I don't see that going away.
Yeah, I agree with everything that Allen said. I think you'll see a little bit of a culture change in that, compliance is still going to be a very key component of what they do, but I don't think they'll take a shoot first, aim later approach. I think they'll be much more surgical in how they do that, understanding the impact on the marketplace, both from a consumer. I mean, they are the Consumer Financial Protection Bureau, and they have admittedly not studied the impact of some of the things that they've done on consumers. So I think you'll see a lot more surgical approach to how they handle enforcement and rulemaking and those sorts of things. But the other thing that I'll mention, I think that this potential change in the CFPB is going to have a trickle-down effect where you're going to see the potential for state attorneys general to be much more aggressive, particularly those that are of the political persuasion of the current administration, perceiving that their baby has now been thrown out with the bathwater, so to speak. So I think we have to be prepared for that.
They continue to have UDAP authority.
Absolutely.
And that's in Dodd-Frank.
Absolutely.
Well, closing point here, as mentioned, 2017 is very quickly approaching. Allen, Shaun, just what's beyond the presidential changeover and those ramifications, just what's on your radar in the compliance world as we turn the calendar?
Really, the change in Washington is the major thing for me. I mean, it's there are so many variables that could happen, and it's just I think it's gonna be really interesting to see how it plays out.
And Shaun,
I think that's right, and I think it's helping everybody not to move their eyes off the target of compliance too much. It was a remarkable election to be sure, but compliance is going to continue to be a big thing in 2017, and it's not something that we can take our eye off of.
Allen Denson, partner with Hudson Cook, Shaun Petersen with NIADA. Please give this gentleman a wonderful round of applause.